trabalhar na promoção dos direitos humanos, transparência, justiça administrativa e na luta contra a corrupção, de acordo com o disposto nos estatutos da ONU. De um ponto de vista temático, este enfoque revela-se com especial intensidade em certas áreas de atuação, como, por exemplo, na matéria do sistema penitenciário, dos direitos dos reclusos, na promoção e divulgação do conteúdo de cada um dos direitos, liberdades e garantias fundamentais. Aí jogam, muitas vezes, os direitos mais nucleares, ligados ao princípio da dignidade da pessoa humana. Estas prerrogativas são aliadas à capacidade de intervenção por iniciativa própria, que permitem ao provedor de justiça contribuir para um maior alinhamento possível da legislação e da prática com o direito internacional em matéria de direitos humanos. Por outro lado, o conhecimento e a experiência adquiridos pelo provedor de justiça no exercício das suas funções permitem-lhe fornecer às entidades internacionais uma perspectiva imparcial e detalhada da situação dos direitos humanos, que os habilita a desempenharem a sua missão de modo mais informado. Minhas senhoras, meus senhores, cada Estado tem o dever primário de proteger a própria população de violações graves e contínuas de direitos humanos, assim como das consequências das crises humanitárias provocadas quer pela perda da natureza ou pelo homem. E os direitos humanos estão cada vez mais presentes como linguagem comum e substrato ético das relações internacionais. Infelizmente, a experiência ensina-nos que, com a frequência, a legalidade prevalece sobre a justiça, quando a insistência sobre direitos humanos se faz sobressair. O respeito pelos direitos humanos deve estar erradicado principalmente na justiça, fruto de um sentido comum de equidade, baseado primariamente na solidariedade entre os membros da sociedade e, por isso, válidos para todos os tempos e para todos os povos. É fundamental fortalecer os mecanismos de combate à falta de transparência, justiça administrativa e corrupção por meio de leis mais rigorosas, sistemas de controle e fiscalização eficientes, punição adequada aos violadores dos direitos humanos, a promoção da educação, da ética, da cultura e da integridade são medidas essenciais para prevenir a sociedade e as instituições provedores de justiça que devem trabalhar de modo a educar a sociedade sobre os direitos e obrigações diante dos atos praticados pela administração pública. As nossas instituições de direitos humanos devem trabalhar para garantir um espaço de modo informal onde se possam apresentar queixas e reclamações para a salvaguarda dos superiores interesses de cada cidadão. O provedor de justiça é a voz firme de quem não tem voz. É a voz do cidadão e o garante da justiça e da legalidade na atividade da administração pública, através de meios informais. O trabalho do provedor de justiça é bastante complexo, exige muita calma, imparcialidade e isenção para prevenir ilegalidades e resolver as queixas e as reclamações do cidadão. Deste modo, declaro aberto a presente webinar e alvitro que cada um de nós deve continuar a promover e apresentar ao Governo, ao Parlamento ou a qualquer órgão competente a título consultivo, seja pedido das autoridades com base no seu poder de atuação por iniciativa própria, parceiros, recomendações, propostas e relatórios sobre quaisquer questões relativas à promoção e proteção de direitos humanos. Muito obrigado a todos pela vossa colaboração, pela defesa dos direitos, liberdades e garantias do cidadão. O cidadão é a nossa ocupação, o cidadão é a nossa preocupação. Desejo a todos um bom proveito neste webinar. Thank you. Merci beaucoup.
Honorable Matza, please take over.
Honorable Martha.
Sorry, I thought I did not know that I'm still muted. Yes, so sorry for that. Let me start by thanking you, Honorable Antonio, the President for AOMA, for setting the tone to this webinar, and also enjoying you in welcoming all the participants to what is already promising to be an exciting and interesting 1.5 hours as we verge into the discussion that is of concern to all of us, as the Honorable President of AOMA has just said, and that is human rights, and also ventilating over the issues on the role that ombudsman institutions play in promoting such rights. Human rights are fundamental to the dignity, equality, and well-being of all individuals, and ombudsman institutions play a critical role in promoting and protecting human rights by providing avenues for redress, addressing grievances, and holding authorities to account. But the ombudsman, the AOMA president, also emphasized on that, on accountability. So this webinar takes place at a time when human rights issues are evolving at quite a faster rate, and when the space for human rights feels to be shrinking. And truth be told, all this requires hands on board. And it is in this space that the ombudsman institutions have to find a place and discharge their functions effectively. Ombudsman institutions serve as impartial and independent bodies that bridge the gap between the citizens and government agencies, ensuring that human rights violations are addressed promptly and effectively. So this is what this webinar is all about. This is what we're going to be ventilating over the next 1.5 hours, and I'm so honored that AORC thought of me to be part of this. We have an impressive panel today that will take us through our discussions. My plea to all of you is that we listen attentively and participate in this webinar fully, and comments and questions at the end of each presentation. So without much ado, and to get the ball rolling, we have the first presenter, who is Honorable Justice Matthew Paua Muhina Mwaimu, who is the Ombudsman of Tanzania. He has a very impressive bio because he's currently the chairperson of the Commission for Human Rights and Good Governance, which is in Tanzania, that is, which is mandated by the Constitution of the United Republic of Tanzania, both as a human rights institution and an ombudsman office. Prior to taking up this position, he was a high court judge. Before that, he was a state attorney who was in the prosecution and also civil litigation space. He holds a teaching, he holds an LLB from University of Dar es Salaam and a diploma in education. He is not new to the human rights space because on many occasions, he has made presentations of reports on the country's human rights situation as a high-level delegate from Tanzania to the Human Rights Council Treaty Body Mechanism, and also the African Commission for Human and People's Rights. Your honors, ladies and gentlemen, I give to you Justice Matthew Mwaimu, who is going to make a presentation on understanding the role of the ombudsman institutions in promoting human rights. Over to you, Judge.
Thank you, Honorable Martha Chizuma, the facilitator of this session. I know we are staying in different time zones, so I can't say good morning or good afternoon, but I can say greetings to everybody who is attending this session. I've been given the assignment to discuss matters relating to understanding of the role of ombudsman institutions in promotion of human rights. In this regard, I will take the discussion through by considering some important matters relating to importance of human rights, because it's our main focus on this discussion. And also, in the due course, I will trace the reason for establishment of Ombudsman, its legal framework and mandate, and also while discussing key principles guiding their work, more focus will be on its advantages against other mechanisms in promoting and protecting human rights. Further, it will venture on actions to be taken by Ombudsman in order to promote and protect human rights. And finally, I'll make my conclusions. I would like to start addressing about the importance of human rights. The Universal Declaration of for Human Rights of 1948, which specifies a good number of human rights and other international and regional human rights instruments, take cognizance that the protection of human rights is a common standard to be ultimately achieved. Human rights as a component of international law maintains that human rights in the Universal Declaration for Human Rights have the character of the principle of jus cogens. This means a peremptory norm, which states are not allowed to derogate. That means every state which is a member of the United Nations is supposed to abide by those human rights principles. From that note, I would like also to mention, because of limited time, about the common principles of human rights, which I believe in this presentation, the participants will may need to understand. Human rights are said to be universal, inalienable, indivisible, interdependent, and interrelated, and they follow the norm of prohibiting discrimination. I will not expound those principles because of limited time, but I would say that human rights contributes to the realizations of persons' human dignity through satisfaction of his or her developmental, physical, and spiritual needs. Taking into account of the principles, the dignity of human rights, human being is prime and it requires protection at any cost. An ombudsman, being one of the mechanisms entrusted to receive and investigate complaints, becomes an important institution in promoting and protecting human rights. Now, I would like to discuss a bit about protection mechanisms under the international law. Under the international law, all human rights instruments have established bodies with mandate to promote and protect human rights. These are in the form of committees and special mechanisms. The Human Rights Council is the highest body in the hierarchy. The Office of the High Commissioner for Human Rights supervises the work of the established human rights committees and special mechanisms. At member states level, governments also have the role to promoting and protecting human rights. The role of governments is to setting policies, enacting laws, and establishing judicial and quasi-judicial bodies. However, government, through its administrative functions, entrusted to ministries, governmental departments, and agencies, give birth to some challenges through acts or omissions by its officers. In order to control government's administrative actions, there are formal bodies established to check these powers. Such bodies are the legislature and the courts. However, the legislature and the courts have been considered to be overwhelmed and insufficient to cope with grievances from individuals. As a result, administrative mechanisms have been established to complement the work of formal institutions. And the Ombudsman is one of these mechanisms. There are some disadvantages by those formal state mechanisms. As I've mentioned prior to this, the main institutions of the state which deals with, among others, human rights are the legislature and the courts of law. Others are the quasi-judicial bodies and sometimes are referred as tribunals, which are established under different legislation. The legislature plays a key role. It frames the legislative rules that provide the ultimate answers and engage in debating in parliament matters of concern to the public. But it has limited capacity to administer laws, as this is rather a practical issue. Implementation of laws is done by the executive arm of the state. The judiciary also plays an important role in deciding the legality of actions in its role under administrative justice. Choose to examine. Moreover,
yeah, he's muted and he doesn't know that he is muted. If there's anyone from Tanzania, from where he is, yeah, okay.
I've unmuted it.
Yes, thank you.
There was
Thank
a
you,
fluctuation, I don't know how or what.
Okay, that's okay.
Okay, so I'm saying that most areas of government decision making receive little, if no judicial oversight. Courts provide only a restricted set of remedies to declare something invalid, enjoying unlawful behavior, requires an issue to be reconsidered and occasionally to award damages. Courts are not able to follow through after having given a judgment or decision to monitor what happens. That becomes the duty of the parties to the matter before the court. Quasi-judicial bodies are established to decide on various disputes in place of courts of law. They are adjudicative bodies constituted, manned, and operated by the executive. Their scope is outside the hierarchy of courts judicial functions. They are statutory tribunals with limited powers to determine disputes and pass binding decisions between individuals and officers in government service. Some of the common quasi-judicial bodies include those set to deal with military disputes, tax and revenue, environment, fair competition, land and housing, labor, and professional organizations established by law, doctors, medical boards, just to mention a few. Tribunals are assigned different mandates consonant to the legislation establishing them. Like courts, quasi-judicial bodies which derive their powers from statute have limited powers as well. They deal with matters that are provided by law. In this regard, they cannot adjudicate matters outside their statutory capacity. However, they make decisions which binds the parties in dispute. Quasi-judicial bodies were established to complement the work of the courts, which with time have complex and formalistic procedures. Much time is needed to adjudicate disputes and they are too costly. The quasi-judicial bodies curtail floodgate of cases in courts of law and reduce workload and congestion of cases. taking calls to functions of the Ombudsman institutions. Now I'm taking calls to the functions of the Ombudsman institutions. The concept of Ombudsman as an institution, as presented before, came out in response to shortcomings in the traditional mechanisms, that is the legislature, the judiciary, and sometimes the tribunals, to addressing the multiplicity and the complexity of problems that people now encounter in dealing with government administrative functions, which in the end raises complaints on violation of human rights and other good governance issues in all areas of government, including human rights. Under normal circumstances, it is difficult to distinguish which type of complaints do not touch human rights, as human rights are part and parcel of human life. Moreover, no human rights violation can take place without a breach of principles of good governance. Therefore, in most cases, in no way can an ombudsman work on a complaint without the same being connected to a human right violation. I would like now to address the advantages of an ombudsman institution in this regard. While other administrative law review mechanisms apply only to a decision made under an enactment, the ombudsman is not hampered in the same way. It is an only independent oversight agency that can review the exercise of non-statutory power. The
Honorable
ombudsman
Judge,
yes.
sorry, you have like 3 minutes, 2 to 3 minutes to wind up.
I see. Okay. So
Yes.
maybe let me jump leave those advantages, and let me address myself to promoting and protection of human rights by ombudsman. The ombudsman is an advantage over other mechanisms, as I have said, in dealing with complaints. Being an independent oversight agency that can review the exercise of non-statutory power without being hampered by technicalities in a form and a procedure, its ability to use fast, inexpensive, and informal procedures, being easily accessible and entertaining complaints without cost to the complainant, it is better placed to deal with human rights complaints. Thus, in order to promote and protect human rights, the ombudsman must do the following. In the first place, it should continue to take prompt action against the violation of human rights, unfairness, or any injustice by providers of public service. Secondly, they should propose both administrative and legislative reforms aimed at improving the operation of public service. Thirdly, they should submit reports to relevant authorities about human rights violations and recommendations on effective means to curtail violations. Also, they should cooperate with human rights structures such as human rights institutions in states where possible through joint organized activities. And further, they should engage public institutions through conferences, meetings, round tables, and forums to discuss challenges and ways to overcome them to minimize human rights violations. Also, they should engage the public through contests and exhibitions on human rights issues. And finally, they should conduct analytical research on source of human rights violations for the purpose of improving observance of human rights by public officials. In conclusion, I would like to say that human rights protection and promotion is ultimately a practical exercise. Human rights coded by international instruments enshrined in states' constitutions and domesticated in states' laws are important and needs to be implemented. The Ombudsman should take the forefront role to ensure that government institutions abide to human rights principles to make people enjoy their rights. Where breaches take place, they should not leave the violations without remedy. That is the only way to remind government officials to abide to good governance principles. With that note, I'd like to end up there and thank you for giving me this opportunity to address this issue. Thank you.
Thank you so much, Judge, and I think you are just right on time. So maybe as a recap, the presentation started with at least the grounding, the concept of human rights, really highlighting that we are all coming from UDHR, the Universal Declaration of Human Rights of 1948, which specified a number of human rights that every individual, every person is supposed to enjoy. And he also mentioned and emphasized that the human rights in the UDHR have a character of jus cogens, meaning that you cannot derogate from them. And I think this is a part that he really touched me, where he emphasized that the satisfaction of the promotion of human rights really is about satisfying human dignity. You know, once you satisfy human rights, you are actually protecting or satisfying the human dignity that each and every person, by virtue of being a human, is supposed to enjoy. And therefore, he emphasized on the need for protection and highlighted a number of protection mechanisms, starting from the Human Rights Council, which is like the highest authority on matters of human rights, but also scaled it down to the protection mechanisms at governmental level, where he mentioned ombudsman institutions as to one of those mechanisms. And he, I think at the end, tried to justify why ombudsman institutions are the best in protecting human rights. Two of the points that he raised being that it's independent, and it can do its work without being hampered by all these restrictive bureaucracies that other forums have, like the courts and others. But it's also fast and inexpensive. Yeah, so the Ombudsman institution becomes a very preferable platform for protection of human rights because it's fast and it's inexpensive. And I think to wrap it up, he said, it's one thing to have all these human rights provisions provided for in different documents, conventions and whatever, constitution and whatever, but it's the practical experience of those human rights. And that the Ombudsman institution is at the center of ensuring practical enjoyment of those human rights for the citizens of any country. So once again, thank you very much, Your Honor, for such an enlightening presentation and indeed for setting the tone of the webinar this morning. We now go to the second presentation, which is will be done by who I've just come to realize today that is my old friend, Mr. Steve Onu. I will not try to mention your surname for fear of me causing injustice to it. But Mr. Steve is an advisor and acting head of the Human Rights Unit at Commonwealth Secretariat in London. He's a seasoned lawyer and an international human rights law advocate. He's serving as an advisor, as I've already said, and acting head of the Human Rights Unit at Commonwealth Secretariat in London. He holds a Bachelor of Laws degree from University of Lagos and Master of Laws degree in International Law and Justice from Fordham University Law School, New York, USA. He is a solicitor of the Supreme Court of Nigeria and has been in the private practice. After serving for a number of years, he joined the UN, and he has an extensive international career working for the United Nations Secretariat, New York, and other UN agencies, focusing mainly in the field of rule of law, development, access to justice, and promotion and protection of human rights. He has demonstrated practically global experience by driving in-country sustainable human rights initiatives, practices, and standards in collaboration with member governments and intergovernmental, regional, and international human rights institutions across North America, Europe, Africa, the Caribbean, Asia, and the Pacific. He is an engaging communicator, skilled in building positive relationships with stakeholders, and has a senior level change-making background in organization transformation. Wow. Very impressive biography. So as I've said, he's going to be presenting on investigating human rights violations, the mandate of Ombudsman institutions. Ladies and gentlemen, join me in welcoming Mr. Steve to the floor. Over to you, sir.
Thank you very much, Martha Chizima, and thank you, AORC, the African Ombudsman Research Center, for inviting me to this very important meeting. And on behalf of the Commonwealth Secretariat Human Rights Unit, it is my pleasure to participate in this panel and to speak on the mandate of Ombudsman institutions in addressing human rights violations. Thank you, Justice Waimu, for leading on the principles of human rights. It may be important to note that 1/3 of the Commonwealth member states are in the African region, and respect for human rights is a core shared value enshrined in the Commonwealth Charter. Under this, strengthening effective national human rights institutions and frameworks are a core pillar of the work of the Human Rights Unit in the Secretariat. Ombudsman institutions are key to this, as they play a critical role in supporting victims of human rights violations to assess redress. Although mandates of the Ombudsman institutions may vary from state to state, jurisdiction to jurisdiction, in my presentation, I'll strive to look at the opportunities that are within the core mandate of the Ombudsman institutions to investigate human rights violations, as well as other related opportunities to address and promote human rights issues and key underlying principles. First, I would like to touch a little bit on the roots of the concept of the Ombudsman institution, which relate back to 1809 in Sweden, when an Ombudsman for Justice was established. In Swedish, the term Ombudsman means representative of the people. While each Ombudsman institution may have its own legal basis in their country's constitution or enabling legislation, this underlying purpose of being the representative of the people underpins the functions and purposes of the Ombudsman institutions around the world. With respect to distinctions that exist in the respective mandates of Ombudsman institutions, participating in today's webinar regarding receiving complaints and conducting investigations, and particularly with some ombuds persons being able to accept and investigate complaints around the allegations of violations of human rights. Others are limited to investigate complaints of alleged governmental maladministration, and others being able to investigate both kinds of complaints. And Tanzania is an example of that. It's a hybrid institution that is both an ombudsman and a national human rights institution. Well, a common minimum element of ombudsman institutions is to have a mandate to investigate public institutions. With this, there's a fundamental human rights element. The investigation mandate of ombudsman institutions, as the government, its agencies, ministries, and representatives are the primary duty bearers responsible for the protection of human rights within their respective jurisdictions or countries. Although in recent times, there are emerging areas of human rights. Most people have heard about business and human rights, where corporations can be held responsible for violation of human rights within their space. And considering the fact that some corporations are actually richer than states, some states, and they have employees all over the world. So the traditional notion of human rights being the responsibility of the state is shifting to encompass some private actors as well. So a broad interpretation of Ombudsman's institution mandate is very important. It's key. Some have constitutional bodies. They're embedded in the Constitution, some by enabling legislation. But whichever model, the interpretation, the liberal interpretation of this mandate, looking at the historical perspective, in terms of what it represents, the protector of the people, representative of the people. So every interpretation of Ombudsman or legislative provision has to bear this in mind, the spirit and the letter of such a law. And that should provide parameters for effective, credible, and impartial investigations on complaints with human rights dimension, including in circumstances where human rights are not explicitly indicated in the scope of complaints under an ombuds institution's mandate. What this means is, as long as human beings are involved, if you talk about maladministration, you're talking about maladministration against human beings. So issues of rights naturally will be embedded. But the interpretation, how to be able to unlock the principles of human rights in such situations is very key, is very important. And it speaks to so many things, skill sets, personnel, and so on. So although not all maladministration complaints may have a human rights dimension, many should. For instance, delayed or wrongful action or omission by a public institution may lead to a violation of the right to access to justice, remedy, or the right to health, employment, or education. And these are also economic rights that are very important and for which the Ombudsman institution is supposed to handle and pay attention to. So, one, the adoption of regulations, policies, and procedures to guide the effective and consistent approach to investigations are crucial to upholding credibility of Ombudsman institutions to both members of the public, for which he represents and serves, and the public institutions within his authority to investigate. In other words, you have to come up with standard operating procedures that will inform your investigations. And this is very important because the investigations, the receiving of complaints, the complaint handling system that be such that even people in remote areas should be able to complain when their rights are threatened or violated. And the Ombudsman institution should be able to position itself in a way that it receives these complaints and it has guidelines or standard operating procedures with which to address. And that will involve, well, interpretation of your mandate, finding in itself to get to the facts of the matter. It will involve legal analysis, gathering of evidence, first of all, to be sure it's within your mandate, and to be sure, even if it's not within your mandate, can it be in another institution's mandate so that you can do a referral system? So what it means is that cooperation with other entities will be key to effective investigation of human rights. Okay, now we're talking about when a complaint comes to the Ombudsman. But there are cases too where the Ombudsman him or herself can initiate inquiries of his own. What the lawyers call suo motu, on his own. And for this to be effective, it is critical that staff are monitoring emerging trends and systemic situations impacting human rights and good governance in that country or jurisdiction. This power also provides a unique opportunity for ombuds institutions to investigate critical human rights issues occurring in the state. The utilization of this power can be critical to investigate human rights issues impacting persons in remote areas of the country, or issues impacting on vulnerable groups, such as persons with disabilities, children, the elderly, indigenous people, ethnic, religious, indigenous or linguistic minorities, asylum seekers, refugees, migrant populations, etc., etc. So what it means is that the Ombuds institution will rely on third-party information at this point. And that is where the role of media becomes very critical, to monitor the media space, both social and mainstream, to be able to be abreast of issues that are within that system, and to be able to sniff out human rights issues and human rights violations. So skill sets and personnel are very important in this as well, in this kind of endeavor. Also, the Ombuds institution, of course, will do initial assessment, gather its evidence, do its legal analysis. Then what next? Sometimes, in fact, most times, there may be need to dialogue with authorities that may have been responsible. Dialogue in the sense of, wanting to hear the state's response to some of the complaints you're getting, whether the one that came to you or the one you did on your own. And that gives you a balanced understanding of the issues. And you should be able to come with initial assessments and then recommendations. Some years ago, in a particular country, not too far from where you are, AORC, I remember an ombudsman who was the man of the year 4 times. Why? Because this ombudsman made determinations on human rights issues for which the state complied 99.9% of the time. Why? Because the man interpreted his mandate boldly, liberally. And again, this ombudsman was firm in being the representative of the people and protecting the rights of the people. And the state couldn't match his arguments. And the state complied, I said 99.9% of the time. So it's important. Now, we have hybrid institutions like that of Tanzania we're using as example. They have ombudsman mandate and they have national human rights mandate, which means they have to comply with the Paris principles. And Paris principles is very key in terms of operational independence, budgetary independence, and its linkage with the international system, and being part of producing the alternate reports, which is used at the UN Human Rights Council, Universal Periodic Review process, or the international treaty bodies reports in itself. So, and to gather these national alternate reports means a lot of investigation on trends and patterns.
You have 3 minutes.
All right, thank you, Martha. Now, there are wider opportunities for the Ombudsman to provide advisory to the state on human rights, both in terms of patterns and trends, and doing its own monitoring and reporting, and raising awareness on its own compliance mechanism. Because somebody in the population should know, how do we raise a complaint? How do we assess the Ombudsman institution? How do we complain? Do you have a hotline? How those in the villages, how can we? There should be awareness of your compliance mechanism, because that helps in investigation. And there should be wide dissemination of your reports and statements and recommendations and determinations and opinions. And of course, the referral system I talked about and cooperation with other entities. Now, for all this to be effective, there are key principles I want to highlight here. Now, the Ombudsman institution has to be neutral and impartial. It has to be inclusive, non-discriminatory. It has to be transparent. it has to be accountable. It has to be accessible by the people. And timeliness, promptness of action is important. And confidentiality, protection of whistleblowers and victims. I think these are key things that Ombudsman institution should bear in mind as they embark on investigations. I would wait till question and answer to be able to, address and to be able to add flesh to some of the points I tried to highlight here. Thank you very much for listening. Back to you, Martha.
Thank you so much, Steve. Thank you. And thank you once again for keeping time. I'm really interested to know, who is this ombudsman who won Person of the Year 4 times?
Malawi, that was your predecessor, before.
Oh my goodness. Oh my goodness. How could I forget? Yeah, yes. I'm so proud to be associated with him and the country, really. But just to a bit of a recap, in brief, the presentation really gave us a background as to why should ombudsman be involved in human rights. So it's why ombudsman. Ombudsman is a representative of the people, someone who speaks, someone who bridges the gap between those who are governing and those who are being governed, and someone who can go to the governors and present the issues that people are facing and be able to translate or interpret the responses to the people that are being governed on the ground. So representative of the people. And so based on that, the fundamental mandate of the ombudsman is to investigate government institutions, because, as you've put it, government institutions are the primary duty bearers for protection of human rights. And so there's need that as ombudsmen, as we are discharging our functions, regardless of whether the human rights protection mandate is explicitly in the law, the constitutions, or whatever legal framework that is creating our office or not, we need to have a broad interpretation of our mandate to make sure that it's covering human rights. And then, of course, he mentioned of different investigations that ombudsman embark on. The first one, the usual one where there's a complaint, but I think he made mention of what we call the own motion investigations, and where how effective they are, because the issues that own motion investigations, especially when they become systemic, they touch the most vulnerable of our society. And I think, coming from my background of being Ombudsman of Malawi, I remember during that time when we did a number of such kind of investigations that had such a huge impact on the vulnerables of the society. I remember the investigation we did regarding street children, coming from really just a newspaper article on some injustices that had been occasioned on some street children, and also the investigation that we did regarding the removal of uteruses from young women in various central hospitals in the country, a complaint that we generated simply from the media reports. And so really just to emphasize the point that in those kind of investigations where you are really touching the delicate hot issues affecting the vulnerable people, monitoring the governance issues as being reported by the media, mainstream or social media, is very important, and is very important to the ombudsman institutions. So once again, thank you so much, Steve, for such an enlightening presentation. We now go to the last presentation for today, to be done by my old friend, Honorable Paul Due, who is the 7th Ombudsman of Ontario, and the president of the North America chapter of the International Ombudsman Institute. He has overseen the largest expansion of jurisdiction in Ombudsman Ontario's history to more than 1,000 provincial government and public sector bodies. His office handles 25,000 public complaints annually, and his recommendations have prompted widespread reforms, including inspections of long-term care homes, de-escalation training for police, enhanced tracking of inmates in segregation, and help for people with developmental disabilities. Mr. Dube was Canada's first taxpayers ombudsman, promoting fairness in the Canada Revenue Agency's treatment of taxpayers. In June 2021, he received the Ontario Bar Association's Tom Marshall Award of Excellence, honoring his contributions to public sector law in Ontario. This morning, he's going to be talking to the issue that Steve touched on, but also something that is very close to my heart, and I'm sure to most of you who are part of this webinar, addressing systemic human rights issues, challenges, and opportunities. His presentation will be through a video recording, but nevertheless, ladies and gentlemen, allow me to welcome Honorable Paul Dube, Ombudsman of Ontario, Canada, to make his presentation. Thank you.
Well, a good morning, afternoon, or evening to you, wherever you may be in the world, and thank you to the AORC for this invitation. It's my pleasure to speak to you today. The webinar's goal has been stated as enhancing awareness and understanding of the vital role played by ombudsman institutions in promoting and protecting human rights and fostering a culture of respect for fundamental freedoms and accountability in diverse contexts. I think that aligns very well with the mission of Ontario's Ombudsman, which is to be an effective agent of positive change for the people of Ontario by enhancing government and public sector fairness, accountability, transparency, as well as a promotion and respect for rights. So I think that that aligns well with today's themes, and it's my pleasure to speak to you today about that. I will share some information about how we fulfill our mission as an Ombudsman institution in the province of Ontario, in Canada, and particularly with respect to promoting human rights in our specific context. Next slide, please. I would like to begin today with an acknowledgement that the Ombudsman's office is in the City of Toronto, and that the City of Toronto sits on traditional territory of many Indigenous nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. We believe it is important to offer a land acknowledgement as a way to recognize, respect, and honor this territory, the treaties, the original occupants, their ancestors, and the historic connection that they still have with this territory. As part of our commitment to reconciliation, our office provides educational opportunities to help staff learn more about our shared history and the harms that have been inflicted on Indigenous peoples. And we are working to establish mutually respectful relationships with Indigenous people across the province. So Megwitch, thank you. Next slide, please. So I'm speaking to you today from the Canadian province of Ontario. You'll see it here on the slide. Canada's population is about 40 million people, and Ontario is Canada's most populous province with about 14 million people. And we work out of Ontario's capital city, Toronto, which has about 3 million people. So our staff of 186 people deal with about 25,000 cases per year, and we're pleased to say that more than half are resolved within 2 weeks. Unresolved cases may lead to investigations, and we are very successful in conducting impactful investigations that lead to positive social and policy changes. Next slide, please. I'd like to share with you that I was at a panel discussion at an event for law students last week, and I was asked if my organization was a catalyst for justice. And I replied that it most certainly is. First of all, with respect to access to justice, I remember that as a trial lawyer, I used to say rights don't do you much good if you don't know about them. And so our work begins with facilitating access to justice. By raising awareness of rights, we help people who are struggling to access services or not being treated fairly by government. For example, while we do not advocate for individuals, our interventions help people get hearing dates for tribunals, obtain written reasons for administrative decisions, or have applications for benefits that were rejected due to technical errors get reconsidered. And we also are a catalyst for justice in outcomes. Our interventions lead to changes that see justice done in a number of ways, such as seeing that rights are respected, that people are treated fairly by government, and that laws and policies are improved to deliver more fair outcomes. For example, our recommendations on the use of solitary confinement will ensure that human rights are respected. Our recommendations to address cuts to French language programs at a university will ensure that language rights are respected in the future. Our recommendations to children's aid societies are aimed at ensuring that the rights of vulnerable children and youth are respected and that their voices are heard. So the promotion and protection of rights is at the heart of our mission and mandate. Next slide, please. Something I quote quite often when I explain the Ombudsman role is a decision by the Supreme Court of Canada in British Columbia versus Friedman. And it talks about how the important role of the Ombudsman to counter situations where individual rights are being crushed or ignored by the bureaucracy. And what the Supreme Court of Canada said is that the Ombudsman represents society's response to these problems of potential abuse and supervision. The unique characteristics of the Ombudsman render them capable of addressing many concerns left untouched by the traditional bureaucratic control devices. The Ombudsman is impartial. The services are free and available to all. Because the Ombudsman operates informally, investigations do not impede the normal process of government. Most importantly, the Ombudsman's powers of investigation can bring to light cases of bureaucratic maladministration that would otherwise pass unnoticed. The Ombudsman can bring the lamp of scrutiny to otherwise dark places, even over the resistance of those who would draw the blinds. Next slide, please. So you can see here on this slide an example of some of our engagement with human rights. In our work, we look at fairness, and in taking and resolving complaints, we encounter many issues where people's rights have been infringed upon or they have been treated unfairly by a public body. Our office oversees more than 1,000 public sector bodies, including provincial and municipal agencies, as well as services in French and child welfare services. Many of these cases include our most vulnerable citizens, inmates in correctional facilities, young people in youth detention or youth justice facilities, or children receiving welfare services from the province. Other examples include people who may have rights to specific social benefit programs or services, but are unable to access these services, or perhaps they experience delays or other hardships in receiving them. And we have oversight of many of Ontario's administrative tribunals, one of which is directly responsible for determining whether an individual's human rights have been violated. When we find that an individual was not treated fairly, we make recommendations to the tribunal to address the problem or address any underlying problems related to Ontario government legislation, policies, or programs applicable to the tribunal. Next slide, please. I can tell you that we receive between 3,000 and 5,000 complaints every year about correctional facilities. We do a lot of work to ensure that inmates know about us and how to easily reach us. You'll see here our poster, which is posted on the ranges within correctional facilities. We also use these confidential self-sealing blue letters, which guards are not allowed to open after the inmate has completed it and sealed them to be sent to us. We work proactively with correctional facilities and the relevant ministry to flag complaints and resolve issues. We share statistics on the complaint numbers with senior staff at the facilities, as well as the top areas complained about. And as mentioned, when warranted, we will launch an investigation into individual cases or systemic issues. Next slide, please. And one such area, and my focus for today, will be Ontario's adult correctional centres, and one case in particularly that severely impacted the rights of inmates. I will not refer to federal corrections as they are beyond the scope of my authority as a provincial ombudsman. Recent media reports show that among the average 9,000 people in custody in provincial detention centres in Ontario on any given day, 82% are usually in pretrial detention, while only 15% have been sentenced. The remaining 3% are usually in custody for other reasons, such as immigration detentions, police lockups, or federally sentenced offenders. Next slide, please. So we continually monitor complaint trends in corrections, and we prioritize cases where urgent medical care is needed. Here are some of the issues you see on the slide, which we monitor regularly and will escalate for senior officials as needed. Next slide, please. So let me tell you a little bit about segregation in Ontario and what that means. Segregation is also commonly referred to as solitary confinement. And that is the practice of confining an individual in custody to a cell by themselves, separate from the general population, with limited social interaction and supervised or restricted privileges and programs. Some refer to those in segregation as being placed in a prison within a prison. Inmates who are segregated can be denied access to amenities and programs, even basic dignities such as shower access, exercise, and fresh air. Next slide, please. Between April 1st of 2013 and March 31st of 2017, our office received 827 complaints about segregation, and there were 560 inmates in segregation in Ontario at any given time. So we saw an increase in these numbers over the years, and we made a submission to government to try to improve some of the processes surrounding segregation. However, not much changed. Next slide, please. In October of 2016, we became aware of a 24-year-old Indigenous man named Adam Capay, who had been held in segregation in a Thunder Bay jail for more than 1,500 days. That's over 4 years. And yet the ministry had neglected to include his placement in the statistics regarding segregation placement and the durations. He was living in a plexiglass-fronted cell under bright lights, which were never dimmed. So obviously, important issues of administrative unfairness and human rights were at play. We knew through complaints that some inmates were being segregated, sometimes without justification, and that their segregation stays were not being tracked properly. We discovered that the correctional system and its processes for tracking and monitoring segregated inmates really needed a complete overhaul. The growing number of complaints about segregation proved that this was a burgeoning systemic issue. The issue affected individuals across the province and affected a variety of policies and processes, not to mention the human impact was significant. So we decided to do a systemic investigation. Next slide, please. Our investigation was completed relatively quickly. It revealed a systemic failure of tracking in the segregation of inmates, and particularly vulnerable inmates. We discovered numerous instances of inaccurate and even inconsistent information used to justify lengthy segregations. In one case, for example, the ministry identified 5 inconsistent segregation start dates for one particular individual's segregation period. Our review also found significant deficiencies in ensuring inmates with mental illness or physical disabilities were physically monitored. Ultimately, we made 32 recommendations to limit segregation placements and strengthen oversight of them. I'm happy to say that the ministry accepted all of these recommendations and so far has implemented 29 of them. Next slide, please. Now, the media and social media coverage was extensive, and this put a lot of pressure on the ministry and the government to accept our recommendations, and that is part of our procedures. Next slide, please. So the Ontario government responded that it would address my report and recommendations and create new legislation. The new legislation was passed in May of 2018, substantially changing the laws of segregation and reforming many aspects of correctional services in Ontario. Since the report was published, my office continues to monitor and resolve individual cases as they arrive. And of course, we do have the power to reopen our investigations when and if necessary. So this case is one example of how the Ombudsman institution can promote and protect human rights and foster a culture of respect for fundamental freedoms and accountability. I thank you very much for your attention. I wish you a stimulating and informative webinar. And if you'd like any more information about my office, the next slide, please, we'll have the information to contact us. So thank you very much for your attention.
Yeah, thank you. Thank you so much. Of course, it's not here, but I think that was quite a very enlightening presentation on how an ombudsman institution can address systemic human rights issues. And I think my attention just went to the investigation, the last investigation that they did, out of sight and out of mind. And again, recalling some of the investigations that the Ombudsman of Malawi has been involved in before. So we don't have much time, but I think it's only right that we now go to Q&A comments from the participants. There are a number of questions that came on the Q&A and also some on the chat. But maybe I could start. So I think I will be asking the panelists to address these questions. Maybe if we could start with the first one that came, I think, on the chat, which said that, will it not serve a purpose if every country entrench their human rights in their constitution, including penalties for violation of those human rights? So I think the point is, if the human rights issues are entrenched in the constitution, will that solve all the problems that we are having surrounding human rights? I think, Steve, you can take that one from your vast experience.
Yeah, thank you, Martha, and thank you, participants. Thank you for the particular person that asked this question, because it's a very important question. It's fair to say most constitutions these days are progressive in the sense that it contains a Bill of Rights. And several legislations you see in countries, touch on one element of human rights or the other. Now, there are international treaty obligations that states enter into, whether it's International Covenant on Civil or Political Rights, or International Covenant on Social-Cultural Rights, or UNCTAD, Convention Against Torture. Many countries sign and ratify these international human rights treaties. For some countries, when they ratify these international treaties, it automatically becomes part of their law. It's holistic. For some other countries, they will need domestic legislation to incorporate these treaties into their laws. But the key point there is that states are under obligation to respect and implement these laws within their jurisdictions. So the courts, they are quasi-judicial institutions like the Ombudsman, the National Human Rights Commission, and several other commissions, constitutional bodies. They all seized with mandates to deal with this. And but the point is this: the citizens or the populations of these countries need to know about these things. So awareness is important, and that's where civil societies are very critical, because civil societies are supposed to bring, visibility to some of these laws. And if you feel that your right is threatened or your right have been violated, you can, complain to any of these institutions. For instance, the Ombudsman institution, you can start from there, or the Human Rights Commission. And from there, they will be able to tease out whether it falls within their mandate or whether they need to transfer you to another institution who are more placed to address this. But as an individual, you have to do something. You have to complain, and when you complain, you have to follow it through. And when you follow it through, you will see that it might take a little bit of a while, but if you're consistent, you'll see that you will get some redress in one way or the other. So the issue of awareness is key. The issue of advocacy is key. and the issue of participation by, population, citizens, residents are key as well. So I'll just, stop at that. Thank you.
Yeah, maybe Steve, there's another question. Maybe you can just extend to your response, where the question is, how does one navigate a situation where a country has both an ombudsman with a mandate to investigating human rights violations and a dedicated statutory human rights body to also do the same? How does one navigate through that? Okay,
wonderful. In fact, that's a good scenario where you have Ombudsman and you have National Human Rights Commission. So, and if you feel your rights being violated, been threatened, my suggestion will be, if the Ombudsman institution is more accessible to you, go for it. If it's National Human Rights Commission is more accessible to you, go for it. For whichever case, and that's why I was talking about cooperation between the Ombudsman and other institutions. Because if the Ombudsman, for instance, feels that your complaint will be better served by the National Human Rights Commission, it's supposed to make a direct referral to that institution in itself. So there should be that coordination that go on within these constitutional bodies, human rights bodies, in addressing the issue of human rights.
Thank you. Good one. All right. So another question is to you, Honorable Judge Mayu from Tanzania. The question is it possible for ombudsman institutions to protect whistleblowers in a country that has access to information laws, but no whistleblower protections? How do other jurisdictions deal with such matters?
Thank you, Martha, for giving me the opportunity to respond to that question. It is true that in Tanzania, it is possible for a person to, our commissioner, for example, to protect whistleblowers, because there are several laws in the country which provides for that. For example, we have the Anti-Corruption Act, which also have that provision. Also, we have, I think we have another law in another institution. There are several institutions. There are several laws which provides for the protection of those whistleblowers. In our case, for example, our commission also is capable of conducting investigations where, for example, a whistleblower's rights have been infringed, because a whistleblower is a person who works undercover and he reports to an intended institution without being coming to face. Now, if there is such an indication, commission has the right and has powers to intervene on that, and of course communicate with the responsible institution to ensure that this person is being protected.
Okay. Maybe related to that, there's another question here, which says that I wanted to inquire, it's coming from Andrew Tamaka, says, I wanted to inquire on the jurisdiction or the powers of the Office of the Ombudsman in interfering with civil and criminal matters with a human rights violation which are pending before the courts of law. From your practical experience, Judge, how have you handled those kind of complaints?
Yeah, there are two dimensions here, because there is a matter pending in a court of law where the court of law has all the powers to adjudicate that matter. But in some other occasions, you may find a person complaining about administrative issues. For example, a person complains that while his case is in the court of law, maybe a magistrate is doing something, or a judicial officer is doing something dubious, which will affect the proceedings of his case. So in this respect, our commission can intervene in this and inquire to the responsible mechanism, responsible officers. For example, it is possible if it is a complaint lodged against a magistrate or a judge, it is possible for our commission to communicate with the leadership of the judiciary to ensure that this person is given his right. And before the matter comes to conclusion, then an intervention can be made. But it is, of course, as usual, as a principle, is that no matter which is in court, an ombudsman can interfere where the proceedings are going on in the right way. So it depends on different occasions as to how and when the nature of the complaint is brought to our attention.
Okay, maybe just from your practical, has that ever happened in Tanzania where the ombudsman has had to intervene on an ongoing matter in court? And how has that not resulted into any conflicts with the judiciary or anything like that? I'm just curious to know.
Yeah, there has been once a case where an individual came to complain that a magistrate, his conduct in the public or some other places where he sees him is like somebody who has been given, he looks like a corrupt person. So what we did, actually, we reported this matter to the Anti-Corruption Bureau to investigate. This is what actually we did.
Okay.
Yeah.
Interesting. Okay. No, thank you so much. So I guess this question goes to you, Steve. Hello, panelists. It's coming from Hussein Valda. Says, hello, panelists and presenters. Thank you for your contributions. May I inquire as to what strategic measures each country in Africa can establish to firstly educate the rural citizenry with respect to their human rights, and secondly, empower them to know the channels to follow if their human rights are violated and they are denied access to channels with which they can rectify the challenges. I would appreciate and invite some guidelines on the matter where rural communities are suffering in different countries. Thank you for your responses. And so, Steve, maybe as you're ventilating over this, have at the back of your mind that the rural masses probably that we are talking about, I mean, it's a common thing in Africa, are those that, compounded poverty, living in compounded poverty kind of situations where probably their main, what they're focusing on, their main focus on each and every day basis is where do I get food? They're not thinking of accountability. They're not thinking of holding, of questioning some things. They're just thinking of food for today. So I just thought I should give a bit of context because I think it's a very important question whose response could probably be enlightening to most of us and actually speak to the challenges, the living challenges that we always grapple with as human rights bodies or anti-corruption bureaus or even ombudsman institutions, in as far as protecting human rights of such kind of people who really have got nothing. But we are talking to them to say they've got rights to this and that, they've got a right to demand. So over to you, Steve.
Yeah, no, thank you for that background, Martha. Yes, and I think that background is key because the poverty profiles of most of these countries are very high, and the rural people are, the poorest of the poor, and there are multi-layer patterns of poverty operating there. So they are looking for bread and butter in itself, rightfully so. And that is where good governance comes in, where a state leadership knows about the social contract theory, that you are holding power in trust for the people. You are not a ruler. You are not an emperor. You are, the people voted for you to represent them. And the critical marker of this representation is access, to the rural population. There are a majority anyway, access in terms of information. And information is not just in English language. It has to be in vernacular, in the languages that they understand, and demystifying, trying to demystify some of these processes and its oppression. And that was why I was talking about awareness raising previously, to say constitutional institutions, which may include, Ombudsman, National Human Rights Commission, anti-corruption bodies. They have a responsibility to reach out to the rural areas, to have a presence in rural areas. Even where you say, well, there are financial constraints, our budgets can't really, you collaborate with civil society groups that ordinarily work in these spaces. But the important thing is that you have to pay attention to what is going on in these rural areas and to be able to, guide, talk, explain in the language that they understand, and the irony of all this is, we can sit down here, wear suits, wear ties and talking about these things, but there's no poor man, no rural person that is here to tell us, who wears the shoes, know where it pinches. But that is the irony of modern life. But I think as a way of intention, you have to intentionally make your presence and your voice, readily available for the people in rural areas. And for information, there's a level of intimidation too with the rural areas. Like you're saying, poverty, is something that degrades a man or a woman's dignity. So even when he thinks it's the right thing, he may not have the confidence. And that is why you have to create that enabling environment that would attract them to be able to come to talk to you. I will give you just in a second an experience I had in a particular country, in Southeast Asia. Then that's a country that was in conflict and they were coming out of conflict. And then we had an office in a rural area to get, receive human rights complaints. And then this lady couldn't come in the day because he didn't want to be seen to be complaining. So he came in the night to complain. And we had to follow up this case, was in prison for a civil matter and got out of prison and so on. But that showed us that there's a level of intimidation that go with the rural folks. And these bodies has to bear that in mind and create that enabling legislation. Whether when you are going to them, you don't need to wear suit and tie. Go in a normal dress. That in itself can help. Talk to them in the language they understand and begin to cultivate their confidence, so that they can understand and appreciate the information you're bringing to them. I think I'll just stop there. Thank you very much.
No, brilliant. I think the key word there is being deliberate and being intentional in your interventions with those kind of populations. So I think my time tells me that we need to stop. But of course, there were a number of other questions that were not addressed, but maybe I should just still be able to give you, if you feel comfortable, because I think it's quite a sensitive question. Either of you can address it. Can one of the panelists please comment on the numerous and ongoing human rights violations in Palestine without absolutely no redress? My Lord Judge, you think you can take that one, or it's going to put you in trouble if you comment?
Let me try. It is true that human rights violations are taking place in Palestine, but unless the question is just only making a comment, but of course that is not good news. It's bad news. But I think according to the regulations or our functions, Ombudsman functions, I think we are working within our states, and therefore in some other occasions it becomes difficult to go beyond our borders, unless if it is AOMA as an institution which can make a statement on our behalf if all of us agrees to make a statement against those violations. But otherwise, it's a bit difficult as an ombudsman to go over and into the Palestine. But our it's possible to make a statement first.
Yeah, okay. Thank you very much. And I'm glad to hear that. A political question that has received a political response. Thank you, and well done, Judge. Steve, I see your hand.
Okay.
Yes, yeah, no, that's a very good response by Justice Waimo. Well, I think there are, if you really want to look at things, there are issues of human rights, humanitarian law, international law that is going on, in the Palestine. But let's be a little bit balanced. This issue started way back, October 7th, when a sovereign state felt invaded by groups abducted their citizens, and they declared war. So that's a war situation right there. And of course, in war, that's why we say, Georgia, don't war. War will always have unintended consequences of civilian casualties because you're using weapons, on both sides. So it's disheartening to see children, women, innocent civilians being killed. But at the end, it takes two to tango. And perhaps the message, which is the message the international community has been putting forward, is, both parties to this conflict should come to a table to have a ceasefire, based on compromises and so on. And we pray and hope that would happen soon to stop the carnage, to stop the killing on both sides, both the hostages to be released, because these are people that has nothing to do. They were just in their lives, living their lives, and people came and just, approached somewhere, being killed. And then look at all the bombing that's going on in Palestine, that people are dying. So that can stop. But it takes the two parties into the conflict to come to the negotiating table and agree. And that's our prayer. Thank you.
No, thank you very much. And I think the recent UN Security Council resolution, hopefully, addresses the issues that we've been horrified with. I mean, just watching TV, it's been quite depressing. So I think I will come back to you, the two panelists, for your concluding remarks, 1 or 2 minutes. But I thought at this point in time, it's only right that I ask the AOMA President, Honorable Antonia, if you have got any words of encouragement or reflections over the webinar. Ma'am, it's your time. Over to you. Are you still with us, Honorable Antonia?
Sim, senhora. Muito obrigada a todos pela participação. Agradecer só aos preletores e o moderador pelas brilhantes intervenções que proferiram. Desejo a todos continuação de bom dia.
Thank you so much, Honorable Antonia. Last words from you, Honorable Judge, Ombudsman of Tanzania.
Thank you, Martha, I've enjoyed sharing some insights about the promotion of human rights by ombudsman institutions. Also, I thank the organizers who gave me this opportunity. And also, I would like to thank and applaud our President, Madam Antonia, for this occasion, because all of us are doing the same job to ensure that human rights are realized. And therefore, I believe our listeners or our people who participated in this have enjoyed or gained something from what we have presented. In this regard, I thank also our research institute for organizing this, and I wish you the best.
Thank you. Steve, your last reflections?
Okay, thank you very much. So thank AORC and AOMA, for this incredible time that we've had, and the participants, and thank you for your active participation. But I'll just leave you with this word that human rights is something that affects everybody. It affects the rich, the poor, the tall, the short, everybody. And everybody has to be interested in it. Everybody has to take it serious. You don't just wait till when your rights are violated. Even when other rights are being violated, you have to be concerned. And for us at the Commonwealth Secretariat Human Rights Unit, we assist ombuds institutions that seek requests from us, in terms of strengthening their structures and strengthening them at all times. So I said, thank you very much and have a great day. Thanks.
Yeah, no, thank you very much, Steve. If there are any presentations that you had, if you could please send them to AOMA-AORC. So that's both you, Judge, and Steve. If you had any presentation, send them to AOMA-AORC so that we can later on send to all the participants who were part of this webinar. And I think at this moment, let me also take this opportunity to thank AOMA-AORC for organizing this quite interesting, refreshing, and inspiring webinar. To also thank the AOMA President, Madam, for being with us, and rather maybe firstly for setting the tone for the webinar with your opening remarks, and also for being with us throughout the webinar, and to the panelists. I think everything was on point from you. It's been quite enlightening. And I think for me personally, it's been quite a pleasure to come back to this space, which I think I shall always hold close to my heart, because I was also once an ombudsman. So once again, thank you all, and wishing you the best of the afternoon. Thank you.
Thank you. Bye.
Bye.
Thank you. Bye.